The moment those lights flash in your rearview mirror, something happens to your brain. Your heart rate spikes, your palms go wet, and in that flood of adrenaline, most Americans do exactly what they were never taught not to do. They go silent, they comply without question, and they hand law enforcement a legal weapon so powerful, so precisely constructed, that by the time they realize what happened, it is already too late to fight it. That is not an accident. That is the system working exactly as designed. And today, we are going to rip that system open and expose every single mechanism inside it, because there are 5 catastrophic mistakes that American drivers make during traffic stops. Mistakes that have cost people their freedom, their property, their clean records, and in some cases, their lives. And not one of them is taught in any driver's education class in this country. Not one. We are talking about what happens in the 15s before your foot touches that pavement. We are talking about the legal gap between your Fourth Amendment rights and your Fifth Amendment protections. We are talking about Supreme Court rulings that most Americans have never heard of, rulings that directly govern what can happen to you the next time you get pulled over. This is not abstract legal theory. This is your life on the side of an American road. If this kind of content, the kind that actually arms you with knowledge instead of just scaring you, matters to you, hit subscribe right now. This channel exists to give Americans what the system refuses to. Let's start with the first thing most drivers get catastrophically wrong. And it is so simple, so seemingly innocent, that it almost defies belief that it carries the legal weight it does. Picture the scene. You were pulled over, and the officer walks up, leans into your window, and says, and pay close attention to these exact words, "Hey, can you step out for a second?" And you open the door, and you step out. Most people reading that scenario feel nothing unusual about it. Of course, you step out. What else would you do? But here is the brutal legal reality that nobody tells you. The word "can" is not a command. It is a request. And in American courts of law, those two things are not remotely the same. Under Pennsylvania versus Mims, decided by the Supreme Court back in 1977, law enforcement absolutely has the authority to order a driver out of a lawfully stopped vehicle for officer safety purposes. That is settled law. Officers have that power. But, and this is the part that should make every American's blood run cold, that authority only kicks in when they are actually giving an order, not when they are making a polite request dressed up to look like one. When an officer says, "Can you step out?" and you silently open that door and step onto the pavement, what does the body camera record? It records a driver who appeared to cooperate voluntarily. It does not record compulsion. It does not record legal authority being exercised. It records what looks to any reviewing court like a driver who freely chose to exit the vehicle. And courts have used exactly that footage, that 30 seconds of silent compliance, to establish what they call implied consent to the broader interaction that follows. You thought you were just being polite. The prosecution thought you just opened the door to everything. And here's the thing about body cameras that nobody in power wants you to understand. They were sold to the American public as tools of accountability for officers, and they absolutely can be that. But they are equally powerful as tools of documentation against you if you do not know how to use them in your own defense. The fix here is one question, one single, calm, politely delivered question that changes the entire legal dynamic of the encounter, that forces the officer to place their actual legal authority on the record on their own camera. In their own words, before you ever reach for that door handle, you look at that officer and you say, "Officer, are you asking me or ordering me to step out of the vehicle?" Say it calm. Say it without hostility. Say it like a person who knows the law, not like a person looking for a fight. Because here's what that question does. It forces the officer to make a choice. If they say it is a request, you now have the legal standing to politely decline, and that declination is documented. If they confirm it is an order, you follow up with one more question. And for the record, what is the lawful basis for that order? Either they cite officer safety under Mims, which is legitimate, or they stumble, and that stumble is now captured forever on their own body cam. You have not been confrontational. You have not raised your voice. You have not broken the law. You have simply participated in it the way every American has the right to. Never open that door until you know whether you are facing a request or an order. That single question rewrites the legal story of everything that comes after. Now we move into territory that genuinely should make Americans furious. Not the kind of theatrical outrage you see performed on cable news, but the quiet, cold fury of realizing that the highest court in the land has made a ruling so counterintuitive, so seemingly backwards, that most lawyers struggle to explain it to their own clients in a way that makes any kind of moral sense. Here it is. The Supreme Court of the United States has ruled that your Fifth Amendment right to remain silent does not protect you automatically. If you simply stay silent, you must speak to protect your right to be silent. Read that again. Let it settle. Because if you think that sounds insane, you are correct. And you are also now better informed about American constitutional law than the overwhelming majority of your fellow citizens. This comes directly from two landmark cases. The first is Salinas versus Texas, decided in 2013. In that case, a man voluntarily answered police questions, but went silent when asked whether shell casings from a murder would match his shotgun. He said nothing. He just stopped talking. And prosecutors were later allowed to point to that silence in court as evidence of guilt. The Supreme Court upheld it because he had not explicitly invoked his Fifth Amendment right. His silence was fair game for the prosecution. The second case is Berghuis versus Thompkins, 2010 A10. A suspect sat through nearly 3 hours of questioning, mostly in silence, and then made one brief, incriminating statement. The court held that he had effectively waived his rights because he had never clearly and explicitly invoked them. 3 hours of silence, and it counted for nothing because 3 words were never spoken. The combined legal rule that emerges from those two cases is this: silence without explicit invocation is not a constitutional shield. It is a weapon that prosecutors can pick up and use against you in court. Which means that every American who has ever thought, I know my rights, I'll just stay quiet, has been operating under a dangerously false assumption. The silence you believe is protecting you may actually be building the case against you. So here's what needs to come out of your mouth, clearly and calmly, before that door ever opens. You say, Officer, I'm invoking my Fifth Amendment right to remain silent. I do not consent to any searches of my person, my vehicle, or my belongings. And I am requesting to speak with an attorney before answering any questions. 3 sentences, 15 seconds. And what you've just done is build a legal structure that protects 3 separate constitutional rights simultaneously. Your Fifth Amendment right against self-incrimination, your Fourth Amendment right against unreasonable search and seizure, and your Sixth Amendment right to counsel. The system is designed to exploit the gap between knowing you have rights and actually exercising them. Those 3 sentences close that gap. Here's mistake number 3, and I will tell you right now that this is the one that gets the most pushback when people first hear it, because it feels overly technical, overly lawyerly, like something only a person looking for trouble would bother with. And that reaction, that instinct to dismiss it as unnecessary, is precisely why it matters so much. Once you have determined whether you face an order or a request, and once you have verbally invoked your constitutional rights, there's one more sentence that must land on the record before your hand even touches that door handle, and it is this: I am complying with your order under protest, and my hands will remain visible at all times. That sentence does 3 distinct legal things at once, and every single one of them matters. First, it establishes your exit as compelled, not voluntary. This distinction is everything. Courts evaluating traffic stop encounters ask at every step whether what happened was voluntary or coerced. A voluntary exit from a vehicle opens the door, legally speaking, to arguments that everything which followed was also voluntary: the conversation, the cooperation, the consent. A compelled exit, documented in your own words on the body camera footage, eliminates that argument before it can ever be made. Second, the phrase under protest is a recognized legal flag. Any attorney reviewing that footage, any judge watching that recording, will understand immediately that this driver was not a willing participant beyond the absolute legal minimum required of them. It signals exactly where your cooperation ended and where compulsion began. Third, announcing that your hands will remain visible is a tactical move that removes a dangerous ambiguity from the encounter. Officers are trained to watch for what they call furtive movements, gestures or motions that could be interpreted as reaching for a weapon or concealing evidence. By putting it on the record that your hands will stay visible, You eliminate the legal basis for a claim of furtive movement that could justify a pat-down search. And then there's the door. Close it when you step out. This is a detail that almost never makes it into legal education content, and it is a significant one. When you exit your vehicle and leave the door open behind you, you dramatically expand what falls under the plain view doctrine established in Horton versus California in 1990. Officers can observe your vehicle interior from new angles they did not have before. A flashlight sweep into an open car is not a search under the law, it is plain view observation. Anything officers can see from their lawful position can potentially be seized without a warrant. Closing that door limits the exposure and forces any further attempt to look inside the vehicle to require a legal basis beyond plain view. These are not paranoid gestures. These are the moves of someone who understands exactly how the law works in these encounters and who is refusing to give the system more than it is legally entitled to. If you are still watching this and you are taking notes, and you should be taking notes, share this with someone who needs it, because this knowledge is not common, and that is not by accident. Now you're outside the vehicle, you've documented your exit as compelled, your rights are on the record, and the officer looks at you, maybe with a smile, maybe with casual friendliness, and asks, "So, how are you doing tonight? Long drive. Where are you heading?" And most drivers, standing roadside with lights blazing on them, with the weight of the encounter pressing down on them, with every social instinct in their body screaming that silence equals guilt, most drivers answer, and in that moment, they begin constructing the case against themselves. Here is what the law actually says. Under Rodriguez versus United States, decided by the Supreme Court in 2015, once an officer has completed the task directly tied to the traffic infraction, checking your license, registration, and insurance, running your plates, deciding on a citation, the legal justification for your continued detention is complete. Any extension of the stop beyond that point requires independent, reasonable suspicion of another crime. Any continued questioning requires a new legal basis. And every single answer you give to those friendly, conversational questions is potential raw material for establishing that suspicion. The officer is not making small talk. The officer is building a record. And the escalation pattern plays out the same way over and over. In traffic stops across this country, officer asks where you are coming from. Driver mentions dinner. Officer asks if you had anything to drink. Driver says just a beer or two, trying to seem honest and cooperative. Now, the stop has become a DUI investigation. Officer asks if there is anything illegal in the vehicle. Driver says no. Officer says, "Well, then you would not mind if they took a quick look, right?" Driver, who has now been talking for several minutes and has established a pattern of compliance, says, "Sure, the body camera has recorded every word of every answer that built." That case, answer by answer, question by question. This is not hypothetical. This is how it happens. The answer to every question after you have invoked your rights is the same. I have invoked my right to remain silent, calm, firm, polite, no attitude, no sarcasm, no aggression. You are not fighting the officer. You are protecting yourself. And when you believe the stop has run its legal course, you ask one question. Has the purpose of the stop been completed? Am I free to go? Under Rodriguez, asking that question on camera forces the officer to either release you or articulate a new independent legal basis for holding you. If they have no basis that is now documented, you are not obstructing, you are participating in the constitutional framework that every American is supposed to be protected by. Everything we have talked about so far, knowing the difference between requests and orders, invoking your rights explicitly, documenting your exit as compelled, refusing to answer questions, all of it is grounded in one foundational reality. The first 30 seconds of a traffic stop determine the legal architecture of everything that comes after. And most Americans blow those 30 seconds completely because nobody ever taught them what those 30 seconds are actually worth. Here's the full protocol laid out plainly, because you deserve to have it laid out plainly. When the lights come on behind you, you pull over safely using your turn signal. You are communicating calm and compliance with the stop itself. If it is dark, you turn on your dome light. Visibility reduces tension and documents that you are not concealing anything. You turn off the engine. You place both hands on the steering wheel where they are visible. You roll your window down 2 to 4 inches, enough for document exchange, not enough to give a full plain view of your interior. Then you wait. When the officer approaches, before anything else happens, you say your phrases. I invoke my Fifth Amendment right to remain silent, and I do not consent to any searches of my person, my vehicle, or my belongings. That is the first sentence. Then, if asked to exit, officer, are you ordering me to step out? And if so, what is the lawful basis for that order? That is the second sentence. Then, when you exit, I am complying with your order under protest and my hands will remain visible. That is the third sentence. Then you step out, close the door behind you, and you stop talking. Now, one thing that must be addressed head on because it has gotten people into serious additional trouble. Officers are legally permitted to lie to you during a traffic stop. This is not controversial. It is settled law. They can claim to have evidence they do not have. They can tell you a witness identified you when no witness exists. They can tell you that cooperating will make things easier. When legally, cooperation changes nothing about their authority to hold you or charge you. They can suggest your story does not match what someone else said, hoping you will revise your account and incriminate yourself further. This is why the invocation matters so profoundly, not because you have something to hide, but because you genuinely cannot know what information the officer has, what they believe, or how anything you say will be interpreted. The only response that protects you is silence and the request for an attorney. One more piece of this, and it is critical. The law varies by state, and general knowledge has limits. In stop and identify states, Texas, Nevada, and Colorado among them, you are legally required to provide your name when lawfully detained. Refusing in those states can result in a separate obstruction charge. That is the law in those states, and fighting it on the side of the road is not where that battle gets won. In states like California and Oregon, you have broader protections and can decline to identify without creating additional legal exposure. In Colorado and Maryland, courts have significantly restricted the use of marijuana odor alone as probable cause for a vehicle search. In Texas and much of the Southeast, that odor still provides probable cause for a full search under current case law. Know your state because the Constitution is the floor and state law builds the room above it. Now let's talk about what this is really about, because everything we have covered so far, the 5 mistakes, the case law, the exact phrases, is important, critically important, but it exists inside a much larger story that the American legal system would prefer you never connect. The knowledge gap we have been describing tonight is not random. It is not the product of oversight or neglect. This country has built a legal system of extraordinary complexity and then systematically denied ordinary Americans the education they would need to navigate it. We fund driver's education to teach Americans how to operate vehicles. We do not fund constitutional education to teach Americans how to operate within their own legal rights. And that gap is not neutral. It serves someone. Think about who bears the heaviest costs of not knowing these rules. It is not people with lawyers on retainer. It is not people who went to law school. It is working-class Americans who cannot afford to fight a charge after the fact. It is Black Americans who face traffic stops at disproportionate rates and for whom the cost of a wrong word at the wrong moment has been catastrophic, lethal, documented, and still insufficiently addressed. It is rural Americans who trust institutions reflexively because they were taught to, and who discover too late that that trust was exploited. It is immigrants who are terrified to assert any right because asserting rights feels dangerous. It is gun owners who carry legally, who know their Second Amendment rights cold, but who have never been told that the Fourth and Fifth Amendments are what protect them. The moment those lights come on, the Supreme Court is ruled, the case law is established, the rights exist on paper for every American equally, but paper rights without knowledge are not rights at all. They are theatre. The system profits from your confusion. Every time a driver answers a question they did not have to answer, every time someone consents to a search out of social pressure rather than legal obligation, every time a person's silence is used against them because they did not know they had to speak, the system gets a result it could not have obtained from an informed citizen. That is not justice. That is exploitation dressed up in procedure. And the response to exploitation is not compliance. It is education, It is the disciplined, calm, legally grounded exercise of rights that exists specifically to protect you from the moments when power and ordinary citizens meet on the side of an American road. Your 4 phrases, commit them to memory, like your address, like your social security number, like anything you need when it counts. Am I free to leave? I invoke my 5th Amendment right to remain silent. I do not consent to any searches. I want an attorney. 4 phrases, 30 seconds. The architecture of protection the founders built and that centuries of case law have refined. You do not need to be afraid of law enforcement to want to know this. You do not need to be a radical or a cynic or someone who hates police. You need to be an American who understands that rights unexercised are rights surrendered, and that the system does not remind you to exercise them. And that reminder is what this is. That is why this exists. Because in 2026, after everything this country has been through, after every documented case of civil rights violated during a traffic stop, after every body camera video that showed a moment where one sentence could have changed everything, and ordinary Americans still do not know what to say before they open that door, now they do. Subscribe, share this with every driver you know, because knowledge of the law is not confrontation with the law, it is participation in it. And participation is the only thing that has ever made this country better. Stay informed, stay protected, stay safe.